Good morning. Welcome. Thank you, Tom, for the introduction. Delighted to be here today, helping put this policy conference together and working with Tom for many years. And I think this program has really come together quite nicely, and we're very, very privileged today to have a very exciting second panel this morning. Our moderator this morning is a young member of Parliament named Rechie Valdez, the member of Parliament from Mississauga, Streetsville. And a lot of people look back in the 2021 and say, you know, there wasn't a lot of change between the 2019 election and the 2021 election. But there was a couple things that changed. And one is there were 14 new members of Parliament elected that day, a couple very, very bright young ones from the Greater Toronto area. One of them was Rechie Valdez. And when we were planning today's event, colleagues that was also elected that day, Leah Taylor-Roy, the member of Parliament from Aurora, Oak Ridges, Richmond Hill, said, you know, you really should ask Rechie Valdez to moderate this panel. And Leah wrote her, and Rechie wrote back right away saying he'd be delighted to do that. We're delighted to have her with us today because in her short time, 16 months in Parliament, she's made quite a name for herself. She's the first female member of Parliament of Filipino origin in the House of Commons. But that's just a small part of it. She has a rich background as an entrepreneur. She has a rich background in community work. And when she arrived in Parliament, she has served proudly on two committees where she's really making a difference. One is the Agri-Food and Agriculture Committee, but also the Veterans Committee. Both very important to have young urban voices on those committees. She's also chair of the Canadian-Filipino Parliamentary Friendship Group. On November 19th, she introduced the concept of a National Women's Entrepreneurship Day for Canada to have permanently ingrained in Canada as a day to celebrate women entrepreneurship. She herself being an entrepreneur. And I asked her why November 19th, because in her bio it didn't say. And she said, I chose November 19th because the United Nations and 140 countries around the world already have a National Women's Entrepreneurship Day on that date. It could have been in March 8th with International Women's Day, but it was too important an issue just to leave to one day a year. So I was delighted that she was able to join us. She's doing a great job in Parliament, and to have her with us today is just a delight. Would you please join me in welcoming our moderator today, Rechie Valdez, Member of Parliament, Mississauga, Streetsville.
Thank you so much, first of all, for inviting me to be here, and it's really an honor even to listen to the previous panel. I've learned quite a bit just being here for a little while. Thank you so much to all of you for taking the time to spend some time to learn a lot about what we're talking about. I think it's really important that we do that and to get more educated. So I have the privilege and honor of introducing this amazing panel today. But yeah, so such an important topic with regards to populism. So I'm joined by these three amazing panelists beside me, and we'll start with Adam Goldenberg. So after graduating from Yale Law, Adam clerked for Supreme Canada's Chief Justice Beverly McLaughlin. A member of both the Ontario and New York bars, Adam served as adjunct professor at the University of Toronto Faculty of Law from 2017 to 2019. Adam is currently a partner at McCarthy Tetrault LLP, where he specializes in litigation. Let's give Adam a round of applause. Dr. Caitlin Salvino. Welcome, Caitlin. So a University of Oxford graduate with a doctorate in philosophy, Dr. Salvino is a junior fellow at Massey College, a law graduate, and Dr. Salvino has studied in Washington, D.C. as a Fulbright Killam Fellow and at the Hague Academy of International Law. Let's all welcome Dr. Caitlin. And we also have Dr. Dutil, a professor of politics and public policy at Toronto Metropolitan University. Dr. Dutil is a former visiting scholar at Massey College and holds degrees from York University and the University of Montreal, and as a senior fellow of the Macdonald-Laurier Institute and at the Bill Graham Center for Contemporary International History at the University of Toronto. Dr. Dutil is a professor of poli-sci. His work focuses on power Politics in Modern Canada. His publications include Politics and Policies for a Modern Canada, Prime Ministerial Power in Canada, Its Origins under Macdonald, Laurier, and Borden, and many more. His focus is on political and public sector leadership, the evolution of politics, and the election analysis. He covers a variety of topics related to policy information, both in the past and the present. So let's all welcome our panelists. So we'll start with having them speak a little bit about the topic, and we'll start with you, Adam.
Thank you, Rechie, and good morning, everyone. First of all, I want to thank Massey College for including me today, and Tom Axworthy in particular, for the very generous invitation. I was saying to Tom at the break that I feel entirely outclassed by all of the other panelists today, including my two colleagues here and our distinguished moderator. So thank you, Tom, for the compliment of their company. My topic this morning is judicial appointments, and I want to speak about the notion of what that means in a populist age, picking up on the theme of this morning's seminar. The premise of these comments is that judicial appointments will remain a human undertaking and will not be replaced entirely by artificial intelligence. Polly, I'm sure, could do as adequate a job as any judge in this country of deciding some of the issues that mere litigators like me bring before us. But for now, we're stuck with humans. And I should say before I go any further that though I practice at a law firm, my comments today are on my own behalf only. As appellate judges say, I am speaking only for myself, and that applies to everything that I'm about to say. I'm going to organize my comments today into two headings. The first is I'm going to provide some framing remarks just about the idea of judicial appointments and populism. Concepts may or may not fit together. And then I'm going to advance three propositions, particularly in relation to the comparison between Canada and the United States, because when we think about populism and judicial appointments, our minds understandably shift very quickly to the situation in our neighbor to the south. What's interesting about the idea of populism when we're talking about judicial appointments is that the judiciary is, and is supposed to be, fundamentally an elite institution. It is an elite institution that is staffed by elites who are selected from among the members of what is essentially an elite profession, the legal profession. And that, as a starting proposition, makes it difficult to apply this idea of populism and the shift towards more populist rhetoric in our politics to our courts and to the judicial process. This is made doubly the case because even in countries where there are populist governments and leaders in power, the courts still are supposed to fundamentally perform a counter-majoritarian function. That's a term that those of you who've studied law may associate with a professor named Alex Bickel, who wrote a book in the 1960s describing the judiciary as the least dangerous branch of government, the branch of government that does not have the power to enforce its own decisions, unlike, in particular, the executive and to a lesser extent, the legislative branch of government. And a counter-majoritarian elite institution is an obvious target in any populist situation because you have, by necessity, by definition, a group of elites chosen from among an elite profession making decisions that bind everybody else, that bind the majority, and the purpose of which, in order to sustain the democratic framework in which judicial systems operate, is often to countermand the decisions that are made by majoritarian institutions, legislatures like the executive. And so how do appointments fit into that paradigm? Well, judicial appointments, when they are made by members of accountable or representative branches, are in principle supposed to align jurisprudential outcomes, the decisions that this counter-majoritarian elite institution called the judiciary make, with popular sentiment, with public opinion. That's why we consign the task of appointing judges to politicians, because there are situations in which we want the ultimate form of accountability of the judiciary to come at the time when judges are replaced, when staffing decisions about who sits on these courts are made. Because as history teaches us, and very recent history among it, judicial appointments can shift the trajectory of jurisprudence, can change the law in meaningful ways. And now, it may now be drifting again to what's happened in the United States, to the reversal of the decision of Roe against Wade and the Dobbs decision last year. That's the most recent contemporary example of changing the staffing on the United States Supreme Court having a discernible and intended impact on the trajectory of constitutional jurisprudence in a democratic society. But we can look back, and I'm going to talk about some historical examples, essentially in the United States in particular, where this has happened. And we don't always think of these examples as negative ones. So let me tell you about one in particular, a situation in which a populist, democratically elected regime used judicial appointments to change the course of jurisprudence in the US. Happened in the 1930s. In 1936, in the height of the Great Depression, Franklin Delano Roosevelt was the Democratic nominee for president and the incumbent. He won one of the greatest electoral victories in the history of any democracy, any fair democracy. He won a third, his Democrats won a third of the seats in the House of Representatives, 3/4 of the seats in the House of Representatives and 3/4 of the seats in the Senate. Complete wipeout of the Republican opposition. And of course, FDR himself retained the White House. That's a massive democratic mandate by any standard, and it was in 1936 as well. And students of history will know that the FDR regime in the United States had confronted the Great Depression with a series of programs that were known as the New Deal. And the New Deal took on an activist role of the federal government that far exceeded what had ever existed previously in the United States, at least since the Civil War. A federal government that intervened directly in the economy and in the lives of Americans in unprecedented ways. And that democratic program, democratic in the capital D and lowercase d senses, was thwarted at every turn consistently by another institution of the US government, the Supreme Court. Since the early 20th century, a line of cases that began famously with a case called Lochner versus New York, the US Supreme Court had taken a essentially libertarian approach to the freedom of, or what's known as substantive process under US constitutional law, essentially holding that the powers of the federal government to do the things that FDR and his Democrats were trying to do were unconstitutional. This was a matter of intense aggravation to FDR and his New Dealers. And so after the 1936 elections in 1937, he proposed a fundamental reshaping of the US Supreme Court, a court packing plan, as it was known, which would have called for the appointment of new judges to that court in order to change the orientation of its jurisprudence. We've heard similar calls in recent years following the appointments made by President Donald Trump. One of the reasons that the court packing plan didn't happen is it became the subject of intense political opposition, including from Democrats in both houses of the Congress. But there was also a change in the jurisprudence on the US Supreme Court. Famously, Justice Owen Roberts, who had voted with the so-called conservative or libertarian majority, striking down New Deal programs, in 1937 in a case called West Coast Hotel against Parrish, changed his vote, switched to the side upholding New Deal programs, and what has followed since then, until the 1990s when a lot of this was rolled back by the Rehnquist Court, was an approach by the US Supreme Court that was enabling of New Deal programs of activist government. And this was a fundamental change. It's known, by the way, colloquially, switch in time that saved 9, because had it not happened, there would have been more than 9 judges on the Supreme Court. And the implications of this have been felt in US jurisprudence ever since. It was such a significant watershed moment, following as it did after these 2 massive election victories, 3, presidential and then both houses of Congress, in 1936, that this has actually been characterized as an informal amendment to the United States Constitution. Bruce Ackerman, a professor, famously made that argument a couple of decades ago, that the Constitution itself actually changed, not in any written sense, but the unwritten Constitution changed in the United States because of these judicial appointments, which were made on the wave of massive populist sentiment, a populist economic program brought in by a Democratic administration. And you don't find many people these days talking about the New Deal in negative terms. So when we talk about populism having judicial appointments, my first framing comment is that isn't ipso facto a bad thing, or it doesn't have to be. At least it wasn't in the United States in the 1930s, unless you have politics that are today considered retrograde. So it's not necessarily undesirable to see an impact of populism on judicial appointments. What is undesirable, I would submit, is when judicial appointments are made not to align jurisprudence with mass public opinion, Ackermanian constitutional moments, informal amendments to the Constitution sense of the term, but when appointments are made to align jurisprudence with partisan objectives, with partisan interests, rather than public opinion. And that's a distinction. If I were a proper academic, I would take the time to define those terms. I'm a litigator, so I get away with fudging these things all the time. There is the distinction that I'm thinking of is when it is the interests of a political party, the supporters of that political party, who likely do not represent the majority of the democratic polity that are being advanced through the judicial appointments. That's where we have problems, and where I would suggest we see the United States heading now if they aren't already there. So the problem I would submit with what we've seen in judicial appointments in the United States is not that populism has had an effect on the judicial appointments process, but that partisan politics has. That's the difference between the New Deal and the appointments that were made under the Trump government in the last 5 years. So if the problem in judicial appointments is partisanship, how does that problem express itself, or how does it pervade and become an issue that concerns us when we're talking about unwritten constitutional principles, chief among them the principle of judicial independence? Well, when you have partisanship infuse a judicial appointments process, when people see appointments to a high court, a constitutional court like the U.S. Supreme Court, infused by the interests of the Republican Party and the Democratic Party in a country like the United States, the risk is that judges are not seen as independent of the political process. The judges who are put in office, though once they're there have life tenure, they can't easily be removed unless they're impeached in the U.S. system. Those judges are seen to be an extension of the political parties that are in office. And that makes it more difficult for ordinary citizens who are bound by their decisions, who live under the constitutional principles they interpret and enunciate, to view the judiciary as an independent branch of government, independent from the majoritarian branches of government, which as a normative matter we want it to be. In other words, partisan judicial appointments pose a threat to the unwritten constitutional principle of judicial independence, and this I would submit is equally true in Canada as in the United States. This in turn leads to an erosion of the institutional legitimacy of the courts. If citizens who are bound by courts' decisions aren't confident in the independence of those courts, independent from the partisan forces that shape democratic majoritarian government, then the legitimacy of those courts' decisions, particularly counter-majoritarian in their implications, becomes harder for people to accept, becomes more illegitimate or decreasingly legitimate, which is another important and contested term in political science that I'm not going to bother to define for you today because I'm not smart enough to do it. But this, I would suggest, leads to a situation in which institutional legitimacy diminishes as you end up with counter-majority decisions that aren't perceived as being rooted in a constitutional text, in unwritten principles that are not politically charged, that are not associated with narrow or short-term partisan interests, but rather become associated with those partisan interests themselves. In other words, the counter-majoritarian institution ceases to be a bulwark against bad populism or momentary majorities that seek to enact changes in a democratic society that are not consistent with that society's long-term constitutional commitments, but rather reflect momentary or incidental alignments of particular interests, which we typically expect to see expressed in the democratic branches, in the majoritarian branches, rather than in judging. So those are my framing comments. I now have 3 propositions that I will advance at a very high level, and they are going to be increasingly controversial as I go. The first is that Canada is not the United States. I'm going to articulate a few reasons why I think that is the case, why we are not in the situation that our American cousins are. The second proposition is that despite what the first proposition, Canada could become more like the United States. There is no institutional, normative, binding safeguard that prevents us from ending up where the United States is now. And the third proposition, which may be controversial, wouldn't be all bad if we were a little bit more like the United States when it comes to the way we talk about judicial appointments and the way we conceive of the judiciary in normative terms. And I'm going to cover that briefly at the end when I will have run out of time, so you'll have to challenge me on it when we get to the discussion. So the first proposition, that Canada and the United States are distinct, and there are reasons for this. The first is that there is a tradition, as I alluded to earlier, of elections in the United States, of political contestation, being orientated around judicial decisions, and it goes back to the 19th century. In 1832, the U.S. Supreme Court decided a case called Worcester against Georgia, which was a case in which the U.S. Supreme Court, in very high-level terms, recognized the rights of an indigenous population in what was then the state of Georgia, what is still the state of Georgia, and the primacy of the federal government in dealing with the relationship with those indigenous peoples in Georgia. This was not well received by the populist government of Democrat Andrew Jackson, who was then the president. And most people say this is apocryphal. I choose to believe that it actually happened. Jackson famously said, or is alleged to have said, Chief Justice Marshall, for the great second Chief Justice or third Chief Justice of the United States, Marshall has made his decision, now let force it. This goes back to what I said before about the least dangerous branch. The outcome of this, the populist reaction to this decision, which played out in the political branches we now know of as the Trail of Tears, the forced migration of thousands of indigenous people from Georgia to modern Oklahoma, which led to huge suffering and death. That was a political response to a judicial decision, and it happened in the 1830s. I've already talked about the New Deal. 1954, Brown versus Board of Education. If you look at American politics today and the orientation of electorates in the South now toward the Republican Party, you can trace much of that to the Brown decision of the U.S. Supreme Court under Chief Justice Earl Warren in 1954, and the response to it by segregationist Democrat leaders in the U.S., the pivot away from segregationism by Northern and National Democrats under the Kennedy and Johnson administrations, and the realignment of the South under the Republican Party, beginning primarily in the election of 1964, presidential election of 1964, to the point where we are today, where there are basically no Democrats who are sent to Congress from non-urban areas of the Old South. That came from the decision of the U.S. Supreme Court requiring, as a matter of federal constitutional law, the desegregation of schools in the South, a political backlash against a judicial decision. And then most front of mind in American society, current American politics, the 1973 decision in Roe against Wade, which precipitated, and this is the second distinction between Canada and the United States, the emergence of a distinct and discernible reaction among the conservative legal establishment and political establishment to take active and deliberate steps to change the composition of the judiciary through judicial appointments in order to inculcate a cohort of judges whose approach to judging would lead to outcomes like Roe versus Wade, and indeed would lead to outcomes reversing outcomes like Roe versus Wade. And this has now been actuated in 2022 in the Dobbs decision, as I mentioned. This conservative judicial revolution was fomented intentionally by the Reagan administration under Attorney General Ed Meese, and it hitched its wagon to this school of legal theory, constitutional theory called originalism, which you will have heard, and some of its leading exponents, Antonin Scalia, ended up on the U.S. Supreme Court. Others, like Robert Bork, almost ended up on the Supreme Court. And if you look at the U.S. judiciary now, there's an entire infrastructure that has seeded the ranks of American federal judges with the graduates of this conservative legal talent pipeline, the Federalist Society. Judges, clerkships with judges who were appointed because they were members of the Federalist Society, and then those people become appointed themselves. That's the career trajectory. Justice Neil Gorsuch, now of the U.S. Supreme Court, Amy Coney Barrett, and Brett Kavanaugh. All three judges who were appointed by President Donald Trump follow this trajectory. They are the fruits of this deliberate effort on the part of a political faction to change the composition of the courts and therefore jurisprudence. We've seen nothing like that in Canada, and we still have nothing like that in Canada. And the third difference between Canada and the United States is Americans are more comfortable talking about judges as being Democrat or Republican because Americans themselves are more readily identified along with those political parties. In Canada, to join a political party, you have to do stuff. You have to, at the very least, go onto a website and click a box saying you aren't a member of another political party. You have to sometimes pay money depending on the party that you're joining. There's effort involved. And so as a consequence, it's something like 1 in 600 Canadians is actually formally affiliated with a political party in this country. In the US, you register to vote as a Democrat, a Republican, or an independent. You actually, in order to exercise your franchise, have to go through the process of political identification and affiliation. So people, it's much more easy to think of yourself in the United States as a Democrat, or Republican, or an independent than it is in Canada to think of yourself as a liberal or a new Democrat. That means something different in our society. And so is the case with, just as everyone else is identified with being a member of a political party, or could be very easily, it's easy to think of judges as having been Republicans or Democrats. And so there's less of a threshold, less of a barrier to thinking about judges, the human beings who are doing this judging and who are being appointed in partisan terms than exists in Canada. Those, I say, are the three main distinctions between Canada and the United States. Could Canada become more like the United States? Say yes, but it hasn't yet. And I'm going to suggest some reasons why. The concept that you heard me refer to a couple of times as I discussed the past decisions of U.S. Supreme Courts and the reactions to them in politics was backlash. With respect to Roe versus Wade, there are two American law professors, Robert Post and Reva Siegel, described the reaction as Roe rage, which is a pun that I've always been fond of. Intense reaction to a decision that infiltrates the political process and becomes a key part of partisan discord. We've seen things that have come close to that in Canada, but never in the same terms as the United States. And just to give you one recent example, last year, our Supreme Court decided the Bissonnette case involving the Quebec City mosque shooter, which you will likely have seen reported on. The Bissonnette case concerned the constitutionality of the criminal code, a sentencing provision of the criminal code that allowed judges to stack periods of parole ineligibility. So in Canada, we don't send people away for life. You're there until you die. That's not something that exists, and it never did exist, it didn't exist, I should say, before Bissonnette either. What we do have is ineligibility for parole when you are sentenced for example, first-degree murder. So in this case, the period of parole ineligibility for first-degree murder is 25 years, and the criminal code provision at issue allowed you to stack 25-year periods of ineligibility on top of each other, so you could effectively say, we're locking you up and throwing away the key. This, the Supreme Court unanimously held, was unconstitutional. It constituted cruel and unusual treatment or punishment contrary to Section 12 of the Charter. And this provoked a ferocious reaction from the political branches of government and from politicians. The reaction from Pierre Poilievre, then a candidate for the leadership of the Tory party, now the Conservative leader, was a promise to use the notwithstanding clause if he formed a Conservative government to reverse this decision. And the Liberal government also expressed intense displeasure with the outcome of this decision. The federal government opposed the application that was made in the Bissonnette case. This provision down as unconstitutional, but the Attorney General, David Lametti, said that the government would respect the decision. They were not going to entertain the idea of invoking the notwithstanding clause. So why isn't this becoming an issue of partisan contestation, leaving aside the fact that the politics aren't right on this particular issue? There was no party that said, yeah, we think this is a good outcome in this case. That would be an impolitic position to take. But in situations like this, I would suggest the reason we don't backlash like the Americans see are because of norms of the way our politics operate. There is a strong norm in our politics that you don't run against the court. You don't run against decisions of the Supreme Court and suggest that you're going to modify those decisions, modify the law by appointing different people with different political convictions. And every time someone toes the line of breaching that norm, there is backlash from elites, from media elites, from political elites. And I'll give you an example in a moment. But the other reason is substantive, and it has to do with our law. We have the notwithstanding clause. We're going to hear about that from Caitlin. That's a pressure valve that allows a politician to say, we don't need to change who's on the court. We have this tool that we can use to wriggle out from under a decision that we don't like. And we have Section 1 in the Charter, the reasonable limits clause, which the Americans don't have in their Constitution, which means most cases that reach the Supreme Court aren't about whether a right was limited, but whether the limitation of that right was reasonable and demonstrably justified, which is a much harder issue to polarize people around than whether there is a right to do X, whether the freedom of speech protects Y. So those are structural reasons why we have not seen backlash politically to judicial decisions in Canada that could lead to partisan judicial appointments as they've seen in the United States. But because I promised an example of where these norms have been threatened, you may recall 2007, then Prime Minister Stephen Harper said the following in the House of Commons. We want to make sure that we are bringing forward laws to make sure we crack down on crime and make our streets and communities safer. And here's the part that matters for our purposes. We want to make sure that our selection of judges is in correspondence with those objectives. And there was strong pushback as soon as he said that from the Canadian Bar Association, from opinion makers, from, as I say, mediates. The question is, does that I'm using the word backlash in a different context now, does that elite backlash against norm violations like that still have the same purchase as it does in a so-called populist age? I don't know the answer to that question. We should ask Polly. So where do you get from the point where, at which we've crossed that threshold, at which political reactions to judicial decisions becomes a threat to unwritten principles like independence, to the norms that keep our courts legitimate in the eyes of Canadians. And I'll draw on something that Professor McDonnell said this morning, namely that the erosion happens little by little, sometimes even imperceptibly. And it's, I'm less elegant than she. I was going to use the metaphor of boiling a frog, which is essentially what has happened in the United States over a period of decades. And I would say that the warning sign that we should all look for, the big red flag, is from politicians like, we will appoint judges who will do X, judges who view things in this way, judges who have this attitude. As soon as judicial appointments become the subject of partisan contestation in election campaigns, that's a big red flag that we have headed in this direction. And that, as I say, has not happened in Canada, at least not to my knowledge. So my final and controversial point, which I have no time to make, is that this might not be all bad. If we don't boil the frog, but warm it up just a little bit, maybe that's the worst situation. And the reason for this is that all of these norms that we're talking about proceed from what Ronald Dworkin described as the neutrality thesis. This legal fiction that judges just call balls and strikes, that there are no value judgments that must necessarily be brought to bear in hard cases when judges, particularly in judging constitutional issues, make decisions that affect the rest of us. It is impossible to make judging completely neutral. And I'm looking at former Justice Sharp, who has written an excellent book on good judgment in which he addresses these issues extremely persuasively. So if we consider that if we take that as true, that it's impossible to say judging is not political, and there is no way to do constitutional judging in a truly non-political way. If we accept that, and I think it's hard to dispute it, then is it really a problem that there is politics in the appointments of judges? Surely not, because the politics that go into judicial appointments are what tether this elite counter-majoritarian institution to the forces of public opinion, mass public opinion, in moments where course corrections are necessary. The example that you should remember is 1937 in the United States. It's not always a bad thing necessarily when the counter-majoritarian institution in our system is reined in or its course is changed by appointments that are made for political reasons, even for populist reasons. And in fact, I think it's hard to dispute that change that was enacted by the informal constitutional amendment of the New Deal years, by the appointments that the President Roosevelt made and the threat he made to expand the court, which led to that switch in time 9, did not diminish the legitimacy of the U.S. Supreme Court, but for decades enhanced it, leading to putting the court in the position to, in the 50s and 60s, make decisions like Brown versus Board of Education, Miranda versus Arizona, and ultimately Roe versus Wade. So remember 1937, and my final proposition is that populism in judicial appointments can be a useful corrective as long as you don't boil the frog.
The visual that's in my mind right now of boiling a frog. Thank you, Adam, for really walking us through the influence of judicial appointments. I really appreciate it. So we'll move on now to Dr. Caitlin Salvino.
Great. So my name is Caitlin Salvino. I'm a junior at Massey College. I'm also a current law student at the University of Toronto. The reason why I've been invited to speak on the Notwithstanding Clause is that I did my master's and PhD focusing on the Notwithstanding Clause across the pond at the University of Oxford. And so my master's focused on the unique vulnerability of minority groups to targeting through the Notwithstanding Clause, which is increasingly relevant as populism grows. And then my PhD focused on developing a new interpretive approach to the Notwithstanding Clause as we see more and more litigation going through the courts. Before I begin, I just want to thank Tom very much for inviting me, especially, I'm a little bit younger at the beginning of my career, so I'm really excited to be able to be here. I'm also really grateful to David, Natalie, the staff at Massey who have all supported with this event. So I'm going to jump in. I have a presentation. Great. So I'm going to talk about the intersection of the Notwithstanding Clause in Canada's Unwritten Constitution. And so just to preface at the beginning, I'm not a political scientist. All of my degrees have been in law. So that's really the perspective that I'm going to be focusing on. And I'm really going to focus on two different aspects of the intersection of the Unwritten Constitution and the Notwithstanding Clause. One is constitutional conventions, and would be unwritten constitutional principles. And so just before, getting into the details of it, I'll quickly go over the Notwithstanding Clause. So it's It's known as a political compromise. I know Tom has written a bit about the details of what that compromise was, but it was really viewed as a political compromise that was necessary for us to achieve the patriation of Canada's Constitution in 1902. And so it's a constitutional tool that's available to federal, provincial, and territorial governments, where they can pass legislation that expressly declares an act of parliament or a provision thereof to operate notwithstanding certain sections of the Charter. And the sections of the Charter that can be temporarily set aside, either preemptive or responsively to judicial review, are Sections 2, which are social freedoms, Section 7, which is the right to liberty, life, and security of the person, Sections 8 to 14, which are legal rights, and then Section 15, which is the right to equality. What's important to note is that Section 28, which is an interpretive gender equality clause, was originally included in the first draft of the notwithstanding clause, but then was removed right at the last minute by unanimous vote of the House of Commons. And so right now it's becoming increasingly relevant in Quebec with Bill 21 with the targeting of religious minorities, and that's going through the courts. What's important to note is that the notwithstanding clause in its design excluded democratic rights, sections 3 to 5, and so it can't be applied to the citizens' right to vote, to delay elections within the 5-year required period. And it also was designed to have a renewable sunset clause. And so what's important to note the notwithstanding clause is that it was designed with the goal of creating democratic accountability safeguards. It has to be enacted through the legislature. It can't be done through the executive. Has to be done with an express invocation. The right to vote and the 5-year election cycle can't be set aside. And also the 5-year sunset clause was intended to require this review or this rethinking of the notwithstanding clause every 5 years that would align with cyclical elections. And so when Jean Chrétien, among many other politicians at the time when it was passed, they used a lot of the language of that it would be a safety valve, would be rarely used, only in non-controversial circumstances or to correct absurd situations. And since 1982, past 40 years, that's largely held true. So there's been 25 tabled notwithstanding clause bills, and of these, only 17 were promulgated and effective. 15 were in Quebec and 2 were in Ontario most recently. It's not on my slides, but I think what's really important to note is that since 2018, there really has been a resurgence in the notwithstanding clause. So between 2001 and 2018, there were no new notwithstanding clause invocations in any province. And then since 2018, there's been 7. And so I know when I first started writing my master's, I started writing in response to Ford's use in 2019 with the municipal intervention. And then, every year I had to keep writing and rewriting and adding more and more as it's gone. And so, even in the past year, Ontario used it in the context of a union collective agreement and negotiation. And so now we currently have 8 active clause acts, most of which are in Quebec. And so when I talk about the uses of the notwithstanding clause, I'm often asked if there's a constitutional convention of rare use. And what I would argue is that there's not. And just to quickly go over what constitutional conventions are, they're unwritten rules of the Constitution that aren't enforced by courts. And so they're really viewed as these normative rules that are binding to actors whose authority comes from the actors recognizing that they're bound by these rules themselves. And so if there's a breach of a constitutional convention, it's viewed as an issue of legitimacy rather than legality for the courts to step in. And so a lot of the recognized constitutional conventions are related to the relationship between the separations of powers. So one of the most famous ones was in relation to how we would amend our Constitution before we developed the amendment procedure in 1982, and that was in the patriation reference. But there's also other constitutional conventions about the role of the Governor General in appointing the Prime Minister and Cabinet, and then also the Convention on Responsible Government. And so in the context of the notwithstanding clause, in the patriation reference, where the Supreme Court said that the political at the time, Pierre Elliott Trudeau, could not unilaterally amend the Constitution and bring it to the UK, and he needed substantial provincial consent, they really outlined 3 requirements for something to amount to a constitutional convention. And what I would argue is that none of them are met in the context of the notwithstanding clause. The first is that there needs to be at least one precedent established by the government or the institutions of government. And in this context, the courts will consider both positive and negative precedents. In the context of the notwithstanding clause, there's lots of conflicting precedents as to whether provincial and federal leaders feel like they're bound by a constitutional convention that they cannot use it, except in these rare, exceptional circumstances. And especially in the context of Quebec, it's been openly rejected. In the first year of the Constitution, Quebec passed an act invoking the notwithstanding and applying it to every single piece of legislation they've ever had. And then for 3 years thereafter, they just applied it in every piece since then until 1985. And then in Ontario, since 2018, we've seen this increasing use of the notwithstanding clause. And Premier Doug Ford, in 2018, even said he's not going to be shy to use the notwithstanding clause. And so the balance of these negative precedents and positive precedents where other provinces have not been using the notwithstanding clause really means that there's this constitutional convention of rare political use. The second is that actors must expressly believe that they're bound by a rule, that being rare notwithstanding clause use. And there's really no evidence among political actors that they believe that they're bound by a convention. The drafters, at the time of the notwithstanding clause, expressed their own personal aversions to it, their own belief that it wouldn't be used a lot because the notwithstanding clause that had existed in human rights codes had not been used that much, so it probably won't be used that much in Canada. And what I would argue is that the rare use of the notwithstanding clause that we've seen so far is not because there's a belief that they are bound by a constitutional convention, but because of the actual design of Section 33, where Section 33 is designed to create this increased political right, requiring there to be an express invocation in the legislature, requiring there to be a review every 5 years, excluding democratic rights. And it's from the structural design rather than a belief that actors are bound by a convention that exists here. And then the final requirement of a constitutional convention is that there's a rationale for the rule with an underlying broad principle. And in terms of Section 33, I would argue that it's already designed as a dialogic tool to balance the broad principles of parliamentary supremacy and entrenched constitutional rights. And so any additional constitutional convention of rare use would be seemingly redundant and also would risk skewing this balance that was arguably carefully designed. And so because of these three factors, I would argue that there is a constitutional convention of rare use of the notwithstanding clause. But I would still argue that unwritten constitutional principles have a role to play in understanding the notwithstanding clause and potentially its interpretation. And so separate from constitutional conventions, there are unwritten constitutional principles that I would argue have a role. And so unwritten constitutional principles, they refer to unwritten norms that are essential to our nation's history, values, and our legal system. And the Supreme Court of Canada has recognized that they're impossible to conceive our Constitution without them, and they're the vital lifeblood on vital unstated assumptions on which our text is based. And so I've listed on the side some of the sources of authority that our courts have recognized for them. And I've also included some examples that have been recognized. And so in the secession reference, the Supreme Court recognized four that are listed there, but there are other unwritten constitutional principles that have been recognized, such as judicial independence, parliamentary privilege. And recently, we've seen, this shift in how our courts are responding to unwritten constitutional principles. And so up until 2021, the Supreme Court had recognized that unwritten constitutional principles could both aid our understanding of the written text, but also could be used to independently craft or strike down legislation or craft remedies. And so I listed some cases where that was found. But in Toronto City, which was the litigation that surrounded Premier Doug Ford's intervention in the Toronto City election, where they threatened to use the notwithstanding clause, there was a real divergence in how the jurisprudence is now going to respond to unwritten constitutional principles, where the Supreme Court said that now principles can only aid the interpretation of written constitutional terms and understanding them rather than an independent source of authority to strike down legislation. And in that decision, they even based their reasoning on Section 33, where the majority spoke about how if unwritten constitutional principles were to be given independent effect, this could undermine the importance of Section 33 as a constitutional clause. And so in this case, what had happened was that the notwithstanding clause was threatened to be used and could have been used to set aside freedom of expression under 2B. And if the court had found that 2B had been engaged and the government chose to use the notwithstanding clause, which they never did end up have to, unwritten constitutional principles could have been used to then intervene, or that's what some of the parties were arguing, to limit the ability to apply the notwithstanding clause in those situations. And so, in terms of what I would argue in the context of unwritten constitutional principles, is that I think that even with this decision in Toronto City, which has narrowed the scope of unwritten constitutional principles, at least in the context of judicial review, that they're still relevant to our understanding of Section 33 and potentially the interpretation of it. And so I'm going to use the case of Ontario's most recent 2021, not most recent, they used one more recently, but the 2021 notwithstanding invocation in the Protecting Elections and Defending Democracy Act. And so in this case, the Ontario government had amended the campaign finance legislation. And they amended it in the context of third-party election spending, where they increased the period that third parties were restricted in their spending in the context of elections, and also imposed a spending cap that was arguably quite low. And so in 2021, the Ontario Superior Court found that this legislation was unconstitutional and unconstitutionally infringed Section 2B. And in response, the day after the decision came out, which is kind of the trend for the Ontario government at least, they announced that they were using the notwithstanding clause. And within 5 days, they passed the notwithstanding clause to allow this legislation to operate notwithstanding the decision that found it unconstitutional. And so this legislation stood, and its restrictions on election spending actually applied to our most recent provincial election. So I would argue that this legislation, in the context of unwritten constitutional principles, really reveals this gap within the notwithstanding clause and its structural design. And so, at the beginning of the presentation, when I spoke about the notwithstanding clause, I presented that there was these democratic accountability safeguards that were embedded in the notwithstanding clause. You can't apply it to the right to vote. You can't, elections. There has to be this review every 5 years in line with elections, and there has to be an express invocation that's passed by the legislature, which, would arguably raise the attention for the public to recognize it, for other elected members to recognize it and respond, and for there to be discussion on whether it should be invoked. And in the context of the Protecting Elections and Democracy Act, what is happening is that democratic processes are being undermined, but not in a way that infringes Sections 3 to 5 of the Charter. So democratic processes that were designed and intended to act as an accountability mechanism on the notwithstanding clause are undermined through suspending freedom of expression, which is permitted within the design of Section 33. And so this really shows a paradox within the notwithstanding clause, in that how can democratic processes act as an accountability mechanism if Section 33 is permitted to undermine expression in the context of democratic elections? And this is kind of where unwritten constitutional principles come into play, where the unwritten constitutional principle of democracy has affirmed, in multiple decisions over, arguably almost the past 100 years, that a functional democracy requires this continuous process of discussion, requires there to be deliberation, requires there to be, the public to consider and review and discuss, and then, vote on government action. And so, we have the secession reference where they spoke about that. But Canada also has a really long history of recognizing the intersection of freedom of expression and democracy in the context of unwritten constitutional principles that, really started with this idea of an implied Bill of Rights that occurred in the 30s in a dissent by Chief Justice Duff that has kind of been, haunting or part of Canada's jurisprudence, mostly in dissents, up until, the 1980s when it was recognized in obiter by the supermajority. And I included a quote on the slide. And so really, what I argue is that the unwritten constitutional principle of democracy that recognizes this intertwining between democracy and deliberation and discussion and freedom of expression really reveals this gap in the design of Section 33. And, you know, in revealing a gap, I would argue that it also might be able to inform constitutional interpretation of Section 33. But, you know, I understand that this is not a legal conference, and, you know, discussing constitutional interpretation is probably beyond the scope. But I would argue that, you know, the unwritten constitutional principle of democracy, in addition to showing this gap, can also be used to inform, you know, the upcoming litigation that's both happening in Quebec around an act respecting the state, and also now the litigation in Ontario around this Protecting Democracy Act. And just to conclude, I think that almost every presenter has mentioned the notwithstanding clause in their speeches today, and so I think it really shows that the notwithstanding clause is being increasingly used as a populist tool, and it raises novel questions about its intersection with Canada's unwritten constitution, both in how we understand the notwithstanding clause and how the electorate will respond and how the judiciary will respond. And, you know, even though I argue that constitutional conventions likely do not apply to the Section 33 rare use practice, the unwritten constitutional principle of democracy does. And I think I'll conclude there.
Thank you, Dr. Caitlin Salvino, for going really deep into notwithstanding clause. It's wonderful. And just a quick housekeeping in case your stomachs are grumbling. 12:30 is lunch, and lunch will be served. Okay. So we'll move on to Dr. Patrice Dutil.
I have a PowerPoint. Do I have to click?
I think it'll come up.
Or will it come up? Mm-hmm. Well, first of all, I want to thank Tom Axworthy for inviting me to address you this morning. It's an honor and a privilege to be back at Massey. It's been a while for me, and I'm really happy to be back. I have to talk about populism and public administration. A fascinating topic that I'm sure can wake at night the way it does with me. It's an important topic because the public service is very much part of the unwritten Constitution. The name of David Smith was invoked already earlier this morning, and I want to pay tribute to him. David was a visiting scholar at Ryerson, now TMU, and he was a good friend. He read drafts of a couple of my previous books, and his advice was always to the point and excellent and useful. I want to thank you also for introducing me so kindly, Ms. Rechie. Ms. Valdez, I'm sorry. The public service is part of the unwritten Constitution. It is the visible part of the invisible crown. It is the point of convergence between politics and the administration. It is the secret garden of the crown. This is David Smith's expression. And the secret garden is an important expression because it is not typically a very public organization in terms of expressing the rationale for its actions. It functions under a particular convention, what we have called in the past a bargain between the public sector and the politicians. The convention basically is this, that you will serve a long career in the public service in return for working hard, proving your merit, being neutral, being anonymous, being compliant. At the same time, you will have discretion. Politicians will give you remarkable discretion in carrying out its dictates, and you must speak truth to power. The bargain is, we will give you tenure, we will give you discretion, but we expect honest and truthful advice. Has that bargain been broken? Many scholars have argued that it has, and that it has been broken since the days of Brian Mulroney. We can argue. It's been broken by conservatives, it's argued. It's been broken by liberals. It's been broken by public servants who have crossed the line. Public servants who have not spoken truth to power. Public servants who have carried out the dictates of politicians with little resistance. So what animates? I want to come back. What animates populism? And the literature on this is as vast as it is frustrating. Populism. I'm not talking about organized politicians who are seizing on populism to improve their chances of election. I'm talking about populism in the street. What animates populism? What gives it rise? It's fear of all sorts of things. Is it envy? It is envy. Is it an instability in the economy, in society? Yes. Is it a fear of globalization? Absolutely. Is it about a loss of values? Values around the family, values around faith, values around country, values around freedom. Is it a revolt against the services of the state? There's a lot of room for that. A lot of literature covers that. Is it because there is a perception that the state is not delivering value for money? Is it a revolt against taxation? All of the above, none of the above. This is where the literature is. How does this fit in theory? There is healthy populism and there is unhealthy populism. Canada, I think we forget this, was born in populism. We forget this. We have had revolts in this country protesting the privilege of the government. The 1837 rebellions, obviously, are an important part of that. You could argue that the 1867 Act was a part of that. But we've had, all through our history, populists elected. Canada has survived, whether it's John A. Macdonald, whether it's Robert Borden, who argued against the elite, the political elite and the government elite. Bible Bill Aberhart, the CCF in Saskatchewan under Tommy Douglas. Louis Saint Laurent's crushing victory in 1948. John Diefenbaker in 1948, John Diefenbaker in 58, Pierre Trudeau in 68. Those are all populist expressions. Brian Mulroney in 1984, the last time a government won over 50% of the vote. Is that not populism? I would say it is. So how do you know whether populism is healthy or not? Forgive me, but I'm going to invoke Potter Stewart when he was talking about pornography in 1964. Couldn't really define it, but I know it when I see it. What we're looking at here is whether there is room for an interpretation of populism as a revolt against the state's services. Is it a demand-side factor at play here? In other words, populism is a reaction to the failures of politicians and public institutions in providing services. You look at the Gilets jaunes in France, January 6th in the United States, or even the Freedom Convoy, you can make an argument around that. It includes everything from economic protection to getting a driver's permit. So the problématique that animates me, the problem that comes to mind here is what can the public service do to meet popular or populist demands for better service? What can be done to protect the civil service and its missions to serve impartially and without populist intervention? Those are the issues. And we have a problem because increasingly Canadians do not trust the state. They do trust politicians. This is a survey from last year, 2022, that asked Canadians if they trust the government. The dark line indicates whether people thought that the government is a divisive factor. 45% of Canadians, and I'd love to hear Polly on this. This is a standard Edelman Trust Barometer study. 45% think that government is divisive. 44% think the media is divisive. In comparison, only 33% think that the business is divisive, and 30% think that non-governmental organizations are divisive. This is a real problem. People don't trust government. What can government do? Well, where are we hearing these? We're hearing them in the street. We heard it at the Freedom Convoy. We hear it in a variety of other venues, left and right. But we also have Donald Savoy, the oracle from Moncton, who has written book after book after book over the last 20 years denouncing government's institutions. Donald Savoy, a very sober, rather conservative thinker, saying, what is government good at? A whole book on it. He says, nothing much. Democracy in Canada, the disintegration of our institutions. Power, where is it? So you have a view that is populist in the street. You also have recognized and rewarded scholars like Donald Savoy saying that there's something amiss here. There's a problem in the way the state is delivering its service. There's a vulnerability. This is a study that just came out of the Pew Research Center in the United States. I'm sorry if you can't see it. This is the percentage who say they trust the government to do what is right, about always or most of the time. And I love this because it goes back. It's a deep longitudinal study. You can see that the decline in the trust really starts in the 90s under LBJ, declines dramatically under Johnson, and so on and so forth. You'll see a dramatic increase under Bill Clinton. This is a really unrecognized part of his presidency, this tremendous growth in the confidence in the state, a decline under George Bush, and basically it's been flatlined. Now I wish I can give you the same thing in Canada. I cannot. I do have a study that measured trust in government, comparing Canada and the United States. This is a 10-year-old comparison, so I don't have anything more, but I'll give you more on that in a second. And you can see that the decline in trust in Canada has paralleled that in the United States. A recent study from the Proof Strategies Can Trust Index, they've published one of these for the last 5 or 6 years, shows Canadians have become less trusting since the pandemic started in 2020, especially when it comes to government and politicians. Trust among Canadians is at 34% in 2022, down from 37% a year ago, and 45% in 2018. This was a survey done last year. So we have a problem in that the state is not trusted and thus vulnerable to an unhealthy populist backlash. What is at issue here at the end of the day? We have a contest between popular judgment and expert judgment. There is a fear that the experts do not understand what the population feels, what the population wants, that the elite are making decisions that do not have legitimate, and that creates a soil in which unhealthy populism can grow. The courts, Supreme Court and all the other levels, the various tribunals, the regulators, the departments, the various boards, commissions, and agencies, carrying out judgments that seem to be contrary to the public good. An example of what poor judgment looks like when it's applied to public administration. What happens when you have an unhealthy populist elected to power? And we have Donald Trump as prime evidence number one. This is what populism, unhealthy populism, looks like when it takes over power. If you haven't read Michael Lewis's book, I strongly recommend an excellent writer and who surprised me by seizing on this issue. It's not the kind of stuff he normally writes about. But he and others have documented how under Donald Trump, the authority of the state was undermined in terms of environmental regulation, in terms of agricultural policy, agricultural regulation, in terms of education, in terms of the State Department, even in terms of the FBI and the CIA. How did he do it? Undermine the workforce, derailed the policy process that normally is carried on by the bureaucracy. his impact on the mission of the various state organizations, of the various administrations that make government policy what it is. He attacked the integrity of the various agencies. He attacked the integrity of the programs. He, of course, attacked any scientific evidence that was contrary to his beliefs. That is what unhealthy populism looks like, in undermining the state. The power of appointment in the United States and the presidency is very strong. But I would argue it's a heck of a lot stronger in Canada. The Prime Minister has virtually unrivaled discretion in nominating who he wants or who she wants. But look at this statistic. This is and it didn't get any better. At the 100-day mark, Donald Trump had nominated quite a few secretaries, but look at where the state was undermined. In the nomination of deputy secretaries, of undersecretaries, of assistant secretaries. Donald Trump systematically undermined the state by not appointing people to the offices, leaving a vacuum, leaving the politicians to take hold of what should otherwise be a sacred trust in ensuring that the state has the wherewithal to carry out its. So this has not been a practice in Canada. We have not had a history where offices are left unfilled. We have not had a situation where dubious, like really dubious nominations were made or withheld. I mean, Donald Trump had a certain logic. He refused to submit candidates for various cabinet positions or deputy cabinet positions because he did not want to have the approval of the Senate. If you have the approval of the Senate, then you're accountable to the Senate. You better have a candidate or a person who's not accountable to the Senate. That way you can hire and fire at will without any problems. So we haven't had this issue in Canada, but the threat is there. It's latent. And a lot of damage can be done by unhealthy populism on public administration. So what can we do? Well, I have three answers, and they're not encouraging. My first answer is there's nothing you can do. The second answer is that there's not really anything you can do. And the third answer is, well, maybe there is. So I come to my issues. What can we do to protect public administration from the abuses of unhealthy populism? You have to build up the institution. Legislation is always going to be there, and there's always going to be a threat of legislation. Legislation, however, can be defeated after the next election if it is unpopular. But what can be done? First thing, protect the Westminster system. I think I've been publicly a defender of our current electoral system. I think it works. I think it has worked very well in our country. It is not perfect, but it has also protected us from unhealthy populism. I especially treasure our electoral commissions. They are sacred. They are brilliant. They function well. They win popular legitimacy. Continue. We must make sure that the public service has the tools necessary to carry out its mission. And here, I have to say, there are lots of opportunities, and I'm going to toot my own horn here. 10 years ago, when I was visiting scholar at Massey, I wrote an article called Crowdsourcing as an Instrument in the Government's Arsenal. There's a great deal of potential for the state to ally itself with the population in carrying out certain services. We have a long tradition in this country of crowdsourcing. We should be doing a lot more. Why? Because it can cement a link between the population and the state. We can make sure that the public service is performing, giving it flexibility, giving it an opportunity to rethink risk, its risk management. By promoting better service practice, I point to the Institute for Citizen-Centered Service. This is a 20-year-old institution that nobody's ever heard of. It is, again, a fantastic treasury of practices that should be promoted, that should be funded. Instead, it is literally being starved by cheap governments who don't want to invest in good ideas. Promote the Institute for Citizen-Centered Service. Protect it from the executive. Last but not least, give it that extra layer of protection so that the executive does not undermine it. Should there be more democracy? Should there be referenda and plebiscites? It was actually raised earlier this morning. I think that there's room for that. We don't have a great tradition in this country of actually asking people what they think. Sometimes, but not very much, certainly compared to the United States. Maybe there's something we could be doing in that regard. Should we have more referenda? Should we have more plebiscites? I'm sorry, but I'm going to talk about Senate reform. All right, I am a Canadian. Senate reform should be done. I'm not happy with the current practices in Senate reform, but I'll spare you my rant. We can talk about it later. We need to build a culture of storytelling in the public service. Tell the good stories. Find a way. You will never find a good story on the public service. We have in this country a phenomenal public service regardless of its many, many, many mistakes. Improve protection for whistleblowers. In other words, improve those safety valves that will force the public service to be better. It is utterly remarkable that in this country we barely have any instances of whistleblowing. Now, you may think that as our public service is so phenomenal that nobody sees any problems with it. I find that hard to believe. We have enormous problems, but there is no safety in employees blowing the whistle. We have to respect majority opinion. At the same time, we have to protect and promote minorities. This is something I think Canada has done extremely well. This is a tough line to walk, but we've done it. This is a remarkable country. Now, we mentioned Section 33. This idea of the Supreme Court undermining cumulative sentences, I think, could become a real lightning point. I'm not sure I have the right expression. It is just waiting for a populist to come out and say completely unacceptable for serial killers, mass murderers, to be potentially left out into the public after serving 20 years in jail. A 20-year-old, an 18-year-old would be out in his late 30s. It's an insult to our society. I think the court has erred dramatically. And I'm hopeful that there will be, and I'm sure people are burning midnight oil at the Department of Justice now, trying to find a way to tweak this so that it actually doesn't come to fruition. But judgments like Section 33 are a real problem. And I'm going to come back to Justice Potter Stewart. There's only two things ultimately that can be done. Hope for an enlightened citizenry to combat unhealthy populism. And for that, I think we do need better media coverage. I think our media in this country is utterly mediocre, and it has lost enormous public trust. Until we have better media coverage, find a way to make it better. Maybe it's more, maybe it's more social media. I can't believe I'm saying this. Better media coverage of the stories that are positive. I'm not being Pollyannish here. There is great stories that legitimize the public service that we have. Great, fantastic stories. They need to be told. And unless that is told, we're going to have a vacuum, and inside that kind of vacuum, you will have unhealthy populism. At the end of the day, what to do is build Teflon. We need to build Teflon on our public service in order to protect it, to make sure that the criticism sticks when it's legitimate. And again, I emphasize, I'm not naive here. I know that errors in public administration happen every day, every hour, constantly. But we need to build the kind of Teflon coat that will protect our services down the road and make the kind of unhealthy populism simply an option that is not to be pursued by Canadians. Thank you.
So we heard a lot from our panelists today. They covered everything from the influence of the judicial appointments, the notwithstanding clause, and we went deep into the populism. So I don't I don't want to ask my own questions. You've actually covered quite a bit of it. And I do like the fact that they compared Canada versus the US. That level of context is really great for us to start the discussion. So I'm sure all of you have burning questions. And I see you've got hands going up. So if you can just wait for the microphone to be passed over to you.
Hi, I'm Noah Kahn. I'm a junior fellow here at Massey, and my question is about populism and its consequences. So in political science, there's been noted kind of something of an infinity loop between populism and technocracy, that the excesses of populism demand technocratic solutions, and then those technocratic solutions don't meet the desires of the population, and then so forth and so forth, that they feed into each other. And I was wondering if there's a way out of that loop that any of us see, and if so, what is that way? And feel free to disagree with the premise as well.
Does anyone want to take that?
Yeah, I think there's definitely a link there. If the state does not keep up with technology, the state will undermine its own legitimacy. Whether it's cybersecurity or whether it is your ability to renew your driver's permit, if the state is behind the private sector to a point where the gap is glaring, you are going to have a populist insurrection. I mean, and we saw this, we've seen this in Canada time and time again, but especially through the 1990s, when you really have the beginnings of a democratization of the computer and the rise of the internet starting in the early 1990s. The government got stuck because it was still delivering crappy services. And they're looking at the public sector, the private sector, I'm sorry, and they're saying, well, wait a minute, there's a huge gap here. And this happened, by the way. This happened in the public sector. It was not the politicians. The politicians were quite happy to see the private sector take the lead and the public sector fall behind. A good example is the 311 system. I mean, I don't know how many of you have used 311. I harass these people all the time. I'm a constant citizen. But they're fantastic. Who fought 311? The Fords. The Fords fought it. Rob Ford and Doug Ford fought the implementation of 311. Why? Because they did not want to be cut off from their population. They wanted to solve the problems of the population. I have a problem with a tree. I don't want to call my counselor to fix the problem with the city's tree falling apart on my yard. Whole variety like that. So it's absolutely, to answer your question, I think it's absolutely imperative for the state to keep up with technology. It is extremely costly. The public service has tremendous difficulties in attracting and retaining talent to carry that out, and that's a real problem. This is the kind of stuff that should be keeping politicians up at night.
I can maybe just take a quick stab as well. I understand the phenomenon you're describing to be one in which we have problems, we say, here are the experts, here's the brilliant, biggest minds in the room, they're going to come up with the right answer, or we're going to make evidence-based policy, which is something we heard a lot from the current government in 2015. We hear a lot less of that buzzword now. This notion that we're going to have the best people, we're going to have expertise, and they're going to come up with the right answers, and therefore we're going to have the best policy outcomes. There's a lot of over-promising and under-delivering that results when you have political rhetoric like that. And we saw a huge amount of that during the COVID-19 pandemic. I think if you look at a lot of the dissatisfaction that a lot of people felt about the way that their lives changed during COVID-19 and during the lockdown measures that were imposed, it was frustration with these public health experts who were doing the best they could and who were using robust scientific data, but who were recommending measures that politicians were implementing that were people's minds ineffectual or making their lives worse rather than better in the short term. And we can debate those, but politicians like to hide behind the experts, particularly when they're making controversial or difficult decisions. The solution, it would seem to me, would be to underpromise and overdeliver. Where technocracy gains public support is where a good outcome is achieved, and you say, this is because we did this thing. We have these bright people. If you have, the people know of a certain generation, it was a bunch of Harvard professors who got the United States into Vietnam. So having the smartest people in the world is not necessarily the best way to a good policy outcome, but achieving a good policy outcome by harnessing expertise is a good story to tell, to Professor Dutil's point about storytelling and the importance of the media.
I believe, yeah, go ahead.
I wanted to ask a question about judicial appointments. They're talking about changing how they're made in Ontario. from, the Chief Justice recommending a bunch of names to the Attorney General, to the Attorney General literally saying, if you're interested in becoming the Chief Justice of Ontario, phone me up and talk to me. It seems to me this is rank patronage. What's your opinion?
So I confess I'm not as troubled by that as many are. I ultimately, and this goes to the controversial proposition that I tried to advance, it is a political decision who is going to be the Chief Justice of the Provincial Court in Ontario. It's a political justice who sits on that court in the first place. It's a political judgment who's going to be a member of the Supreme Court of Canada and the Chief Justice of that court. These are all political decisions for which politicians can be held accountable at the next election. This goes to Caitlin's point about the kind of elitist view of the institutions of democracy, and the expressive character of elections need to be protected in order for us to have all the other protections that our constitutional framework affords. So to my mind, I confess I'm not an expert in the current process, and I'm not an expert in what's been proposed, but at a level of principle, it does not, if ultimately it's going to be the Attorney General who makes the recommendation who the next Chief Justice is going to be. Marginalizing the current Chief Justice in that process for whatever reason doesn't strike me to be a deep threat to the independence of the Ontario Court of Justice. But I know that there are strong opinions on the other side of that issue.
Oh, sorry, I think the mic is going to go over.
Some of us in this room are old enough to remember a rather remarkable expression of populist sentiment in Canada that took place 30 years ago. And I'm thinking of the national referendum on the Charlottetown Accord. Governments had negotiated for many months, along with elite groups, Aboriginal groups, and other opinion leaders in society, all met in Charlottetown, I think 1990, and then we had a referendum on the result of their deliberations. And every single government in Canada, I believe, and every one of the groups that have been involved in the consultations were recommending support of that referendum, in that referendum. And for whatever reason, they didn't like what they were proposing to do in that accord for Aboriginals or for Quebecers, whatever reason. The national opinion, almost universally, I think, across the country, was no. And that was a remarkable expression, a kind of populism, whether that was healthy populism or perhaps, as Patrice was suggesting, a healthy way of deflecting unhealthy populism is a good question, but I'm a bit surprised that hasn't come up as an expression of populist sentiment before many in this room were born.
It was Pierre Trudeau against every provincial government.
Oh no, he hated Charlottetown. That maison du egg roll. My only comment would be, it was the wise thing to do, to put it to the people, and the outcome was also quite acceptable, and the issue died down with little consequence. You compare that to what happened in France, where the issue was put towards on greater integration with the European Community, where the issue was put to the people resoundingly turned it down. The French government turned and said, okay, we're doing it anyway. If you look at the protest in the street, if you look at the right-wing protest, the populist protest in France, they still come back to that one decision where the public will was rejected by the elite. And this is a sticking point. The French government, the French state, is still living with it, and of course, for tomorrow is going to be a giant general strike.
Just, we have to go
I
soon.
believe we are, yeah. Last question?
Thanks. So, Professor Dutil, you had asked whether or not Polly had looked at a trust barometer, so I feel like I should respond. Not only have we done one, we presented it to the government, to the public service, and I can tell you it said a lot of things, but one of the things it said is the number one thing driving mistrust among populists, and we presented this to the public service, was the government of Canada's performance in Afghanistan in getting the our allies, are the people who did translation for us and their families out, while people at home watched them being killed. And here we are 3 years later, we still don't have them out, we still don't seem to have a strategy. So is this something where, what is preventing, because you're right, the public service in this is, and maybe the politicians, is bringing down trust, is increasing populism. What can the public service do? Why is it not acting on this issue when they know, because we presented it to them, that it's the number one thing driving
Well, I think
distrust?
the obvious answer is that they're under political pressure to do certain things, and there's all sorts of ways to compromise. The government says one thing, it does another thing. You can have fantastic commitments, but if you don't put the money behind it, nothing's going to happen. The public service, that's why I say the service has to be given the tools, the policy tools, the money tools to do good work. But that's very instructive, and you know, I'm sure we slice and dice all sorts of issues where the state has found, when I say the state, the public administration is found to be failing. But that's a good example. I mean, the issue around Syrian refugees would be another one. I'd be really curious to see what the public perception is on that.
It's all of that. It's all of that. It's the biggest frustration the populists have,
Yeah.
more so than COVID and all that, is the, what are we doing? Our
I have to
foreign
say, I'm a bit
policy.
surprised that this would be at the top, but I'm delighted by it. I'm
With this
delighted
group
by it.
of people, it's
Yeah,
more
yeah,
on the right.
Yeah, yeah.
And I think we're up for time.
We are.
But I just want to thank everyone for joining. Thank you, Adam Goldenberg, Dr. Salvino, and then Dr. Dutil. I appreciate all of your insight. I hope you enjoyed that. I certainly did. I've got some takeaways, and I'm inspired to write a statement in the House come the term. Thanks, everyone.
Thank you.